And although there are many persuasive financial and societal arguments to be made in rigorous defense of intellectual property, I positively loathe when that seems to be the only basis upon which IP is defensible. My argument today is not going to be utilitarian in nature, at least not primarily. My argument is moral and philosophical in nature. Copyright and patent isn't good because it works. It works because it's good.
Oh, so it's gonna be one of those fucking videos? Oh no. Hello there everyone, Esso here. It has been a long-ass time since I've sat down and decided to make a response to some shitty brainlit tier grug post of a video. But the video we're going to be responding to today has been teased by the person who uploaded it for years now, so I and others like me who take the contrary stance to the one espoused in the video have been anxious to see the incredible end product of all these many years of deliberation and plotting required to go into such a methodical rebuttal of all of our seemingly airtight criticisms. And it's probably one of the worst video essays I've ever seen. Given some of the trash Heretic and I have responded to previously, that's seriously saying something. So the original video I'm going to be replying to today is an essay uploaded by Razorfist, or the Rageaholic, regarding the subject of intellectual property, a broad-reaching blanket term used generally to refer to copyright and patent law. Not really a whole lot more I could say to introduce the subject, given that most of you probably know who Razor is and have at least heard of the concept of IP, given how copyright and patent law significantly influences most of our immediate daily lives, more so than any other form of state intervention. Since intellectual property in the social media age has screwed over quite a lot of people who merely try to develop software, create entertainment, or to view these things very directly, and indirectly creates artificial barriers to entry which make it more costly to engage in most interactions, along with increasing the capital intensity of trade or production, and since it's not really possible to monopolize narratives anymore like it would have been 10 to 15 years ago, merely euphemizing these subjects with loaded terms like intellectual property isn't enough to shut down the conversation anymore. Skepticism towards the notion that intellectual property legislation can be justified, whether or not one comes to this conclusion from state skeptic means or otherwise, seems to be a prevailing trend in thought, particularly within the last 5 years. Both Heretic and I around a year ago made a pretty comprehensive essay on the subject of IP for those who aren't familiar with our position. Neither of us are big fans, but if you want to see our general thoughts about IP, I'll leave a link to our video in the pinned comment. Spoiler alert though, I'm going to be reiterating many of the criticisms we'd proposed of IP in this video that we have in that essay, since Razor attempts to directly respond to them. Anyway, so for many years now, our friend Razorfist has been making vague, supportive statements in favor of IP laws on his Twitter page, with the promise that at some undefined point in the future, he'd make a full-length essay about it, definitively proving that IP legislation is legitimate, and completely blowing all the critics out of the water. Essentially, Razor was hyping up this essay and was attempting to lead his audience to believe that it was going to be a revolutionary expansion to the general IP debate, consisting of nuances most hadn't taken into consideration previously, along with possibly some new arguments no one had heard before. Sort of like the Hoppe essay Heretic and I just finished, a position on subjects we don't see defended very often despite us having many serious criticisms which are otherwise somewhat obscure. Instead of an essay of that quality, though, we got a half hour of, well, I'm not going to invalidate the entire purpose of this video and spoil the issues with it in the introduction, but there are takes way worse than this I see posted on a pretty much daily basis from the breadtube side of social media. The reason, despite this fact, I stand by my claim that this is the worst video I've ever seen has everything to do with the context surrounding how this was created, as opposed to the actual end product. Anyway, I'm gonna go ahead and get into this now, but I just want you all to remember while watching that the video I'm responding to today has been in the works since at least 2017. Filthy Heretic didn't even have a presence in the libertarian community when Razor started the script for this video.
The right to the labor of your mind is not an invention of the government or a device of bureaucratic control, although its rollback certainly is, as I will demonstrate.
Okay, well, I was hoping I could give you guys more than 10 seconds without having to listen to me drone on in my trademark Ben Stein-ass nasally voice, but this was a persistent problem throughout the video, and if I were to stop and make note of every instance where Razor does this, this response is gonna be well over an hour long. So, like pretty much anyone who defends IP, Razor prefaces practically every single point he attempts to make or every single argument he responds to by using terms to describe the concepts in question, which presuppose that it's just to conceive of copyrights and patents as a form of property which can be demonstrated and exclusively owned from a natural law perspective. Since the point of Razor's video is to try and demonstrate how copyrights and patents can stand up to scrutiny as a form of legitimate property and how one could demonstrate ownership over a copyright or a patent in a non-aggressive manner, presupposing in every statement that copyrights and patents are a form of property is a logical fallacy known as begging the question. Not to mention, the specific example here I highlighted, the labor of one's ideas, doubles as an example of equivocation, which is a tactic that Razor is also going to employ quite a bit throughout this video. It's commonly used by defenders of IP, and would also be pretty annoying if I were to stop the video every time Razor does this just to point it out. The reason why the concept of property is valid and necessary in ethical philosophy is that people as moral agents are acting upon scarce resources, or inevitably are going to act upon scarce resources. Because a scarce resource can only be defined and transformed by the party acting upon it, and said resource is necessarily limited in the ways it can be defined or used by whoever has dominion over it, the question of rightful ownership, therefore, has to be raised. The entire contention over concepts within intellectual property from the natural law perspective is that since patterns of information don't have a tangible definition, are not scarce, what counts as a violation of any IP claim can be arbitrarily defined, and IP claims would entitle one to claim another person's resources based entirely on unilateral standards, it's not entirely clear how one could even own an idea, let alone all the other questions about treating information as though it were scarce. To refer to information as something which was labored implies that it exists in the same category of concept as a scarce good, when it very obviously does not. And since one of the main reasons IP is disputed as a form of property is because of the fact that information isn't rivalrous in nature, it's very disingenuous to use terms which are designed to imply that this is the case. But anyway, instead of stopping the video every time Razor does this as well, for the first time ever I'm adding counters at the top of the screen. And I'm sure that by the time this video is over, both of those counters are going to be insert Dragon Ball Z reference which stopped being funny in 2008.
It is a human right. Period. Whether acknowledged and enshrined by law or subverted by the very same. To deny the product of a man's mind is to deny the very concept of property itself. Why the fuck do you think cranial body horror is so harrowing in fiction and film? Because the mind is not only a man's property, it's about the only property no other earthly man can touch without our consent. If our minds are affected by others, it's because we permit them to be. No one penetrates the perimeter without a by your leave from our fucking id.
And what exactly does that have to do with the ability to use force against other people for using the resources they have dominion over in a way you've decided that you don't like, under the guise that you're somehow claiming the information to be yours when it's not even clear what you mean by that?
But the Antifa-tards and the party of pot that calls itself the libertarians these days, in arguing against IP, miss the point hardest when they fail to acknowledge that all property is intellectual property. If a man's mind is his primary interface with the world and preeminent instrument of survival, then it's not with his brawn, but with his intellect that a man erects his own dwelling or purchases it. Not with his biceps, but with his brain that he builds a bicycle. Recognizing the physical property that results from it, but not the primacy of the intelligence that created it, is like blaming the beat of nut sweat on the sack of your progenitor for your fucking birth, rather than the will of your parents themselves. I repeat, to deny intellectual property is to deny property. To expend the time, effort, or expense to create a work and manifest it physically doesn't merely create a commercial claim to it, it creates a moral one. Now,
I think this goes without saying, but whether or not someone is a moral agent is not up for dispute here by people who are arguing for this position on the grounds of property ethics. So to cite this as an argument for IP is just a total non sequitur. But now we're getting to an interesting point of Razor's video, and this is something which, to his credit, Razor openly admits, when usually IP advocates are pretty coy here and try to deny that their position necessitates this claim, or try to avoid this particular argument altogether because they realize that this aspect of the IP claim exposes copyrights and patents as a form of state-enforced economic privilege. What Razor is arguing here, and really what proponents of IP in general are arguing, is that you have a property right to actively force other people to not be able to compete with you, or to not use their own resources with information that you've somehow claimed exclusive ownership over. Now, there are proponents of IP who are utilitarians, but they also try to sidestep this implication in the IP claim, because one of the very few accepted axioms in the study of markets, which is near universal in every methodology with the exception of the neo-mercantilists, is that monopolies are not economically sustainable or efficient, even though many of these state-shill schools will positively argue for monopolization if it's called a licensing requirement or the state. And then, of course, there's the myth that monopolies can be established in the absence of state-imposed barriers to entry or other forms of supply manipulation, but I digress because we're starting to get into the question of what defines a monopoly, which is a different subject entirely. Generally speaking, though, it's widely recognized that fewer inputs when it comes to market signals create systemic distortion, is not sustainable to the effect of diseconomy of scale without some sort of state intervention, and also notably introduces various problems with incentives which cause producers to have disproportionate amounts of social leverage over those they interact with. So even when you take the ethical problems with copyrights and patents among other sorts of licensing law or state-imposed barrier to entry out of the question, most people are not going to buy the idea that monopolization is actually desirable.
On questions of duration, reasonable minds may differ. The author's life plus 50 years seems marginally reasonable to me, though I would advance the argument that if an author, filmmaker, or fucking ninjutsu instructor erects an empire of any consequence, imparts to his progeny the significance of it, and deigns that when he dies his family should inherit not just his fortune, but the product of his mind as well, provided some manner of condition for his legacy's continuance be satisfied, who in nine hoary hells are you or the federal government to intercept that property, deny it to the family, and dispense it to the unwashed masses in direct contravention of that fucking desire?
Man, I swear, every property ethic-rooted argument for IP is exactly the same. Question-begging, equivocation, and inevitably resorting to making some sort of vague appeal to incentives or how much wealth the legislation of trademarks, copyrights, and patents have supposedly led to the introduction of and couldn't have been produced otherwise. The reason I pause here more than the fallaciously framed righteous indignation is because I want to highlight how in this clip Razor seems to have conceded to having a view that property claims are arbitrarily imposed by a central arbiter, as opposed to being demonstrated through means derived from self-ownership. Now, I don't think that Razor here, or at least I'm willing to give him the benefit of a doubt and assume that he probably didn't mean to undermine the entire premise this section of his essay was intended to try and demonstrate, but if legislation imposed by the state, saying that the state will defend people they choose who make these claims with violence, is all that's required for something to be demonstrated as a form of just ownership, then fundamentally Razor's perspective has no coherent basis for either framing itself as an argument made positively in favor of property rights, or as a rejection of state intervention into the affairs of non-state actors.
The author's life plus 50 years used seems marginally reasonable to me, though I would advance the argument that if an author, filmmaker, or fucking ninjutsu instructor erects an empire of any consequence.
So on this point at least, I wouldn't be willing to say that Razor is being actively disingenuous, but rather it exposes a fatal flaw in his conception of the issue. He doesn't understand the concept of property, specifically why it's necessary, and how it's a natural emergent product of humans acting upon scarce resources, along with ethical truth claims in general. In fact, following the reasoning here that the basis for demonstrating ownership is merely if the state says that this is how it works, and you can then own whatever you're claiming as long as the state's courts will use violence to protect you, then every claim regarding any subject from Razor's perspective fundamentally is interchangeable, because no one has to demonstrate why their claims are valid or provide a framework which conceptually make sense in understanding why their claim is conceived of the way that it is, and what counts as just claims are boiled down to whatever the central monopoly on arbitration decides, with no base for their claim or means by which they could be held accountable or actually base arbitration around what could be demonstrated. Now, I understand that there are natural law, property-centered arguments which presuppose the legitimacy of the state, and that the state's monopoly on arbitration has basis for demonstrating something to be true. Positions I've been endlessly critical of in the past, and I would argue don't stand up to scrutiny. But keep in mind that Razor prefaced his argument by stating that his argument was an axiom, a logical deduction, and has gone on to frame his understanding of property as something which the state's intervention is fundamentally antagonistic towards. See the introduction. So what we have here is an odd contradictory mix of a logical positivist argument regarding rights claims within a framework where ethical truths have to be demonstrated and based on deductions from logically proven axioms. From his perspective, all you need to do in order to claim that you own something is write on a piece of paper which states that you do. Even if you can't logically show that you own that particular resource, or it's not conceptually justifiable to say that you can exclusively own that resource, for instance, if doing so would entail acts of aggression upon other people's property yourself, and such a claim would justify the burden of proof. Given that he approaches property ethics from this angle, it's not really surprising that he argues for IP, since this framework of property claims being defined merely by arbitrary dictate is fundamentally the only one where IP could conceivably be justified. But since this property theory, as noted before, is entirely arbitrary, and the validity of any claim within this framework is decided by whoever the state says has a valid claim, this is not an argument for property, this is an argument for political privilege and authority thinly disguised as a property ethic. So, in short, there is no world where you could consider harvesting or trading for your own resources, then using them to compete with someone else to be a market intervention in favor of one entrepreneur against another from the government. That's logically nonsensical, and equally so from the perspective of market theory, since neither entrepreneur is destroying resources or appropriating resources from the other in an economically parasitic manner, nor constructing barriers to entry by creating artificial scarcity which allows one entrepreneur to coercively externalize costs onto another part of the economy. I'd go on, but for one, I've more than made my case already, but also because Razor is about to start going over his economic arguments for IP. 3.5 minutes into a nearly half-hour-long rant where the premise was that said rant is supposed to refute ethical arguments against IP and create a strong foundation through which IP could be justified from a deontological perspective. I mean, I'm truly at a loss for words. If an essay arguing for the ethical legitimacy of IP being finished after 3 years of being written can only spend about 3 minutes actually making the ethical argument for IP, which, as a reminder, was almost entirely constructed by snappy-sounding rhetoric which dishonestly loaded practically every statement, with the assumption that the conclusion Razor's trying to demonstrate is valid, which his detractors don't agree with. Which, by the way, has pretty much been the argument for IP since lawyers coined the term intellectual property as a way of equating monopoly grants originally from the feudal political economy, which existed solely to stop laborers from being able to compete with the members of the state's guild system with property claims. That is fucking embarrassing. I could stop the video right here, but I doubt you'd believe me when I say, well, you're about to see for yourself anyway, but the utility arguments Razor goes on to make are actually even more perplexingly stupid than his attempt to establish a justification in the natural law framework.
You mean to tell me Gammy can pass down a hope chest but not her life's fucking work? If Walt Disney, for example, wanted his kids to inherit the fucking mouse, and he happened to have laid down precise strictures to satisfy lest the ownership lapse into the public domain, wouldn't that have been an infinitely more appealing proposition than whatever the Merry Mickey Mouse fuck we have today? Have a gander at my Hollywood Was Always Red video for ready evidence that the Walt Disney Corporation is no longer even faintly fucking acquainted with the philosophy of its founder. The company created by a commie fighter who testified in Congress about their subversion of American power now employs open socialists at Marvel fucking Comics. The Disney of this decade is a corporate perversion, infinitely extending the trademarks for a product they never created to begin with, exposing in the process the hypocrisy of the very same copyright regulations you argue would have prevented this.
So, I nearly glossed over this section entirely because it isn't really relevant to property claims, but it's so absurd I can't not address this. Pretty much inevitably, if you're going to argue from either perspective about whether or not IP is legitimate, at least if you want people to take you seriously, you have to talk about Disney, Nintendo, Nike, Viacom, Warner, or any of these other corporations who have a significant amount of influence in the state's political economy, since these firms in particular are notorious for their regular use of copyright claims as a way to bully smaller media outlets into taking down articles which convey information they don't like, bully content creators on YouTube into taking down videos, bully independent producers and development projects into shutting down development on new products they would have created, just to scratch the surface, not even getting into how the patent office has been used to suppress innovation in a way which would require an entire video to even come close to doing it justice for. So how does Razor, the IP shill, excuse these atrocities of human rights which the institution of IP creates? The most insane mental gymnastics I've seen since Steven Crowder tried to reconcile his defense of state police and militaries with his denunciation of taxation as an act of extortion. So apparently the reason IP has the characteristics which it does that the opponents of IP find objectionable is not inherent to IP claims themselves, but because of some undefined government intervention restructuring how courts enforce copyright and patent claims, which is why IP causes all of the ethical problems that it does and functions as a form of state privilege. Ignoring the obvious, the fact that Razor hasn't provided a justification for IP in a natural law framework, and the fact that there doesn't appear to be any discernible difference between the conceptual problems with IP claims which its critics are concerned with compared to how IP claims are enforced by the states in modernity. The IP critics Razor refers to argue that the institution of IP is inherently illegitimate and ought to be subverted so that it can no longer be enforced. So this pretty naked attempt to shift the goalpost and frame his position as a response to arguments who seek to justify the state creating more layers of bureaucracy in the creation of IP claims falls flat on its face, because it's not addressing an argument that anyone's actually made, or at the very least, none of the positions he's addressing try to promote this position. The latter part of the statement just confuses me. So, the reason that IP is a form of protectionism and state privilege is because of the opponents of IP who want to see the standards for IP become more onerous somehow, which, from Razor's perspective, is a state-imposed regulation on IP and distortion of IP claims. Yeah, this doesn't make sense any way that you look at it.
Is there a more utilitarian imperative at play to embrace copyrights and patents? As I alluded to earlier, fucking sure there is. Economists who chart human development use the shorthand of the hockey stick graph, meaning if a line graph were drafted of the advancement of humanity from the beginning of recorded time to the present, it starts as a fucking plateau, then beginning in the late 18th and early 19th century, it fires off the fucking Neptune. What many economists, particularly, sadly, of the Austrian variety, often neglect to acknowledge is that this sudden surge in technological advancement perfectly coincides with the advent of intellectual property protections in the United States.
Alright, back to the so-called utilitarian base for Razor's IP claims. Now, right off the bat, Razor fails to specify what type of wealth he's referring to. What area of society, which societies, how he's measuring gains or costs, given that a social net gain is an incoherent concept because it's defined arbitrarily with no way of contextualizing what a good is. I've made this criticism before about the empiricist methods in previous videos, but data points cannot coherently demonstrate any claim to be true or false in and of themselves unless there's a necessary explanation of why the way said data is being contextualized and presented is valid. Without a necessary explanation for your premises or the validity of your framework, there's nothing which limits how you could use your data and what you could support with your data. For example, you see Marxists quite regularly citing examples of market prices being very close to, or where the main influence over them is the price of labor input, as proof that the basis of market value is the labor input. There's no conceptual explanation for how this demonstrates value, nor does it address the criticisms of the Marxist labor theory of value, since no one has ever argued that labor input can't correlate heavily with, or even be the exact same price as, a good. But Marxists don't understand the difference between price and value. More importantly, they also assume that inherent in material sensory observations and data is the ability to derive objective truth. So within this framework, there's no way to step back and ask important questions which actually would help us understand the nature of what's being observed without rejecting the framework itself. Like, what area are we measuring? How and why would variables change if we were to change the area? What time frame? Why that time frame? What about individuals setting their own prices in local economies? What are we counting as an economy and why, etc.? And if I wanted to dispute the claim put forward by someone who takes random data and just assumes whatever they're trying to prove is somehow demonstrated by said data, how could I definitively disprove their conceptual claim while just assuming that whatever empirical data I presented was itself evidence against their claim without demonstrating how? Any premise in which data points themselves can be the basis for demonstrating a claim is just a heavily euphemized way of saying that you've made up your conclusion and are working backwards to try and create a pretext for justifying it. Digressing and going back to Razor's argument, clearly Razor either doesn't understand how to write a persuasive argument or is being willfully disingenuous. Given how retarded this section of his essay is, and that you could find loads of historical evidence within just 5 minutes of doing research, which completely destroy the point he's attempting to establish here, I could assume that either is true at this point. So basically, his argument is that the First Continental Congress of the United States implemented the first copyright law in 1790, and within 30 years, according to his own graph, economic growth for the world skyrocketed. It's worth noting as well that Razor cropped out the top part of this graph so that you can't actually tell if it's even established by the creator what area or unit of measurement is being used to create this data. However, one can tell that this isn't just the US national economy, since the timeline starts before the US government existed. Firstly, copyrights, patents, and trademark laws have existed for thousands of years. The Roman Empire and the ancient Greek state, as far back as 500 BC, had copyright systems, and as mentioned earlier, it wasn't until the mid-1800s that these forms of monopoly grants were legally considered property. The first use of that verbiage in a legal context, intellectual property, was specifically in 1845 from a circuit court case in Massachusetts named Duvall versus Brown, and became popularized in the 1870s by lawyers to defend these various grants as property claims. To clarify, literally nothing about how these so-called IP claims were enforced changed. Lawyers just started referring to them as property claims as opposed to monopoly grants created by the state, which they had been referred to for the entirety of their historical existence prior to that point. So, the introduction of copyright, patent, and trademark law to the newly reformed legal code of the colonies as being the explanation for this economic growth, if that's even what the graph is showing, again, no context was provided, doesn't seem to pan out when looking at the historical timeline as an explanation for how this unique economic development could have occurred. This is merely a correlation-causation argument, and that doesn't even remotely surprise me because in every single attempt, even from an empiricist framework, to find whether or not there was a tangible connection between so-called intellectual property grants and any measure of economic growth, have either come away with inconclusive results or found that the opposite was true. But again, this is something anyone who has a grasp on even the most basic of economic concepts could have told you, and we really didn't need studies to know this. The state constructing barriers to entry and making production artificially more capital intensive increases costs of production and makes it so less consumption can occur. Consequently, fewer people can produce. The use of state violence to stop them from competing with IP holders aside, and less wealth in general can be created because fewer people have access to resources.
Every major American invention of the Industrial Revolution, and several great artistic works thereby, were patented or copyrighted, from Eli Whitney's cotton gin to the first commercial revolving pistol. In fact, after abandoning the American colonies and fucking off back to Crumpetopia, when the very first World's Fair was convened in 1850, the old world was awed by the spectacular new inventions on display from the new continent. The repeating firearm, Morse's variant of the telegraph, Goodyear's vulcanized rubber, the sewing machine. What is in the water over in fucking Freedom Land that they went from bumfuck to a Swiss Army inventor in a 50-year period, they asked? The answer? Intellectual property was paramount, not the sole determining factor, but certainly a guiding one.
Awfully convenient that he cropped out the top part of that graph to try and make it seem as if this trend was merely in the US's national economy so that he could lie and wouldn't have to explain how the trend occurring in the US's legal market was also occurring in Western Europe, which, by the way, every Western nation had copyright and patent statutes. Most of them predated the US's.
And an American innovation to boot. When we first started cutting copyright checks and handing out patents to people, most of the old world was still locked in a system of trade secrets and cloak and dagger guild politics. But
listen here, libtard. I've watched enough of that Nazi on Fox News to know that it's different when we do it 'cause Murica. Durka durka dur. Well, that was pretty bad. Not really anything else to go over, though. That, and I'm tired of working on this same video off and on for the last month and a half, and can't really think of an outro because I just want to move on to the next project. Anyway, if you liked it, please comment, rate, subscribe. Tell me what you thought in the comments. I'll be glad to read